Well, hello there, my friends. I'd hoped to get this conversation with Eric Segall up a little earlier in the day, but the day was not mine to plan. Had a huge storm last night and had to deal with that and a couple of other small unpredictables. But here we are, and I have this great conversation with Professor Eric Segall to share with you. Almost an hour where we covered a whole how did we get here when it comes to the overturning of Roe and everything that we are facing with women's reproductive rights as it relates to the Supreme Court. We also talked about the latest on Clarence Thomas's corruption and whether or not he should be recusing himself from anything dealing with January 6th. What with the fact that his lovely wife, Ginny, was there and advocating for it the whole time, as well as the hypocrisy of the conservatives who call themselves originalists but so often don't rule that way, and so much more. This is another great one. It's always a great one. Professor Eric Segall, probably the most frequent guest on the podcast. Who would have ever known we would be so interested in constitutional law? Well, I have been for years, and so many of you have been here along with me along the ride, and as always, this is his interpretation of things. By all means, go find more. You may have your own. We have a lot of legal scholars that actually listen to the program, and I think partly because of Eric Segall's frequent appearances. Anyway, always great. You should get his books. You should listen to his podcast, Supreme Myths. You should follow him on social media, especially on TikTok, where he's always over there explaining, and he's a real good, close friend of mine. We always have a lot of fun. I always learn a lot. But, of course, I cannot do it without your paid subscription. Go to patreon.com/Pete Dominic right now. You are the funder of the show. The show has no ads. It is you. Patreon.com/Pete Dominic. Also, watch my new stand-up special available on Dry Bar Comedy's YouTube station. It's drybarcomedy.com/PeteD to go directly to me. There's also a link in the show notes. I really hope that you'll watch the special. And, of course, March 22nd and 23rd, we're all gathering in Vegas, and I've heard from a few more of you that are going to be there, so buy your tickets. More details to come. Great comedy, great music, and podcast taping. See you in Vegas. But now let's do it with one of our favorites, Professor Eric Segall.
I showered for you.
I don't think you showered for me. We're on. I think you showered, and then it just so happened here we are taping together.
That's not true, actually.
Oh, you really got that spruced up just to be on video with me?
No. I have to leave right after this and have to be showered for that.
Well, you look good, and I bet you smell like an Irish spring or something.
I smell so good right now, Pete. I'm surprised your audience tomorrow or whenever you air this will probably be able to smell through the podcast.
Yeah, and what would they smell? What would it be, like an oak?
You know what they're going to smell?
A leather, like a metal?
You know what I smell like these days?
Leather and metal.
What does retirement smell like?
You smell like fiber?
I want to smell like retirement. That's what I want to smell like.
Smell like a beach.
You know what did it to me? You know what broke me? We'll get into this in a few minutes. But I'll return to the subject. Or you will. You know what's broken me? Amy Coney Barrett. She's mostly broken.
Yeah. How is Amy Coney? She only got her job because Ruth Bader Ginsburg died, right?
Yes.
So they replaced a woman with a woman. That was nice.
They replaced the most important gender rights litigator in American history with a woman who would throw gender rights out the window at every opportunity.
Oh, that doesn't seem.
It's kind of like replacing Thurgood Marshall, the most important civil rights litigator for people of color in American history. He argued Brown versus Board among 22 other cases, and he won most of them, and replacing him with Clarence Thomas. The Ginsburg and Marshall for Thomas and Barrett has had so much of an effect on America. Well, just those two changes.
Start with just, we may know some of the consequences of Clarence Thomas being on the court, but, why are you so worked up about Amy Coney Barrett? What has happened with the Supreme Court since she got confirmed?
So I'm working on so there's two things going on, maybe three actually, with Amy Coney Barrett. Let's begin at the beginning. So Justice Scalia dies in February of 2016, and McConnell won't have a hearing for a year. Right? That's never been done before. It's insane, and that was the beginning of the problem.
Well, Scalia died. Obama, a Democrat, is president.
Yes. If Garland gets that seat, Everything changes.
Obama nominates Garland. McConnell won't have a hearing for Garland.
For basically 11 months, whatever it is.
And then Trump wins.
Justice Ruth Bader Ginsburg passes away. They rush through Barrett in late October, right before the election, which Trump loses. So we really should have Garland plus another liberal. It should be 5-4 in liberals' favor right now, is what it really should be, if they had played by the rules. But that isn't even. I want to make several points about Amy Coney Barrett. I think I made these before in your pod.
Ruth Bader Ginsburg would have made that all easier had she resigned.
I'm not saying that. Yeah,
No?
I mean, as it plays out, yes, but I'm not blaming her for that.
Okay, fair enough. I think I might have been.
The system shouldn't give her the choice.
Right, the system should not give the choice. That's a good point. Go ahead.
Okay, so first of all, when she gets elevated to the 7th Circuit Court of Appeals, which is the only reason she got to the Supreme Court, she had to be a judge first. So she got in the Court of Appeals. On the day she was announced, Pete, there were, and I did the research in the following weeks, there were too many constitutional law professors to name who had better resumes than Amy Coney Barrett. So much. She went to Notre Dame Law School. It's a very good law school. It's not Harvard. It's not Yale. It's not Chicago. At the time she was nominated, all the justices were from Harvard and Yale, except Justice Ginsburg, who went to Columbia and Harvard, but she passed away. So it was an unusual thing in that regard. She wasn't. She just was one of 100 con law professors who could have been elevated. But leaving that aside, she becomes the 4th self-identifying hardcore originalist on the court. So she does not hide what she is. She says, I'm an originalist. She clerked for Justice Scalia. She's an originalist and originalist and originalist, as are Thomas, Kavanaugh, and Gorsuch.
Whatever that means.
Well, yeah. So that's 4 self-identified hardcore originalists. And Justice Alito says he's an originalist from time to time. Sometimes he makes fun of it. Sometimes he joins it. So he's 4.5. Justice Roberts, you can't pin this on him. He has never claimed to be an originalist. That's not what he claims to be. But there's still 4.5 originalists on the court. Since that time, since the time Amy Coney Barrett was put on the court, as I'm writing in a blog post to be published Wednesday, I believe, the Supreme Court has completely revolutionized constitutional law, abortion, affirmative action, guns, all dramatically changed. Separation of powers dramatically changed. This whole major questions doctrine in administrative cases dramatically changed. Now, Amy Coney Barrett has a theory about that. That's not as terrible as the rest, but it would still be a dramatic change. And none of it is originalist. None of it, Pete. None of it. There's no originalism. Sorry.
Well, that's the big point is that in these 3 years that you mentioned case by case, they identify as following the original meaning of the Constitution, the actual text, rather, of the Constitution.
The original meaning of the text is what they
If it's not in there, then it doesn't count. And yet, many decisions that could never be described by that ideology they have passed. Yeah.
So, for example,
so it works when it works. It's originalist when they want it, and not.
So, Pete, your audience knows about the gun case, and they know you and I talked how anti-originalist that gun case is. We've talked about Dobbs a little bit, where I mentioned to you that there's a lot of history in Dobbs, lots, from like the 13th century to the 19th century. But as Noah Feldman of Harvard says, canvassing 500 years of history is not originalism. Originalism is, what did it mean in 1791, give or take a couple years? What did it mean in 1868 in the 14th Amendment? Give a couple years. It doesn't mean you have 6 centuries of material to pick and choose your answer from. And even Randy Barnett, our friend Randy Barnett, described Dobbs and Bruin both as not being really originalist cases. You know, it's interesting, Pete. In Dobbs, the court never asked the question, not one time, what is the original meaning of the Due Process Clause of the 14th Amendment, which is the provision at issue in that case. So what Amy Coney Barrett has brought to the court is fake originalism on steroids. But worse than that, her replacing Justice Ginsburg, as long as Roberts was the key swing vote, this court was not going to do that many terrible things that quickly. It was going to do a lot of terrible things slowly, but it wasn't going to do a lot of terrible things quickly. And in fact, Roberts did not vote to overturn Roe. Roberts wanted to strike down the 15-week abortion ban at issue in that case, say that did not meet the Casey test. and keep on with Casey for a few more years at least. It is only because he is no longer the controlling vote that these decisions are coming out the way they're coming out. Not to mention, he's not an originalist. So if he was the controlling vote, we'd have a whole different set of but he's not. There are 5 people to his right. And by the way, that's a sentence that no progressive law professor ever thought they would ever utter until the day they died. There are 5 Supreme Court judges to the right of John Roberts, who, by the way, is about as conservative as they come. So, I mean, obviously not, because there were 5 more judges more conservative than him. How they found them, and that's an incredible statement right there. But mostly what they're trying to do, and this is where you and I have talked now for so long about this, Pete, but again, with Roberts being to the left of the swing vote, which is Kavanaugh, which is crazy, they are, and it's so obvious, they're pretending in all these cases that they're just looking at text and history when all they're doing is looking at what Republicans want to do. I mean, it's just a Republican Party, even today's Republican Party platform, pretty much down the line, unless it involves Trump personally, and then the court may do some strange, unpredictable things. But it's the same old stuff: end affirmative action, end abortion, have much more gun rights, deregulate the economy, and make sure the president has a lot of power over federal agencies pursuant to the unitary executive theory, which has, by the way, no basis in originalism. And I've had a series of guests on my show who are experts on administrative law, which I don't pretend to be. I don't really pretend to be an expert on administrative law. I can talk about it intelligently. I started writing about it, but all the experts are saying the same thing. There is no originalist basis for the major questions doctrine. There's no originalist basis for cutting down the administrative state. The only people not saying that are libertarians. I wonder why. So why can't they just announce to the world, we are now a court of conservatives and libertarians. We're going to impose our conservative and libertarian values on you. And that's what we're going to do. And we're going to tell you the truth as to why we're doing it. We think people must have guns. It's really important. Self-defense, number one right everybody has. We think affirmative action is terrible because it stigmatizes blacks and it's unfair to whites. We think that abortion should be decided by the states because we're not sure when life starts, and we're going to return it to them. We're going to make sure the president fits this unitary executive theory because in general, we like strong presidents and we don't like strong Congresses, et cetera, et cetera. Instead, they go through 500 years of history and they pick and they slice and they dice and they distinguish, and anyone could write the opinion the other way. You and I could look at that without any research and write the opinion. Because even when they talk about the history in these cases of their own, they talk about it in such a flimsy, transparently not persuasive way that it would be really easy to say, wait a minute, you're talking about case A versus B there. You're saying it said X. It didn't say X, but even if it did say X, the context shows it's either more important than you thought or it's less important than you thought. And 500 years is a long time. So it's just a huge, they're hiding what they're really doing. Government employees shouldn't do that, especially government employees with jobs for life.
Hiding what they're really doing, which you would say is what exactly? They
are deeply conservative, libertarian justices.
They're hiding what they do. Why can't they just come out and say, you got it? So, all right, speaking of hiding what they're already doing, you're going to write up a piece, by the way, about what you just talked about, I think, right? That's going to...
I am, because it's really important people understand. It's also, we don't have to go into this today, Pete. Not only is this an indictment of the Roberts Court being hypocritical, more than that, it's an indictment of originalism as a theory of interpretation. Because even 4 judges who claim to be hardcore originalists have joined decisions and written decisions that are not only are they not originalists, but in the Bruin case, Pete, they're anti-originalists. What he's doing there, the founding fathers would say, what the fuck are you doing? We never, ever thought judges would ever do that. That's what the founding fathers would say.
Okay, so looking forward to that. That'll be published at Dorf on Law, right?
Yes, sir.
And got to ask you...
Pete, let me just plug one more thing. I do have an article coming out in the Fordham Law Review online on how terrible Bruin is, and I'll tweet that out when it comes. I'm proud of that. It's a short piece. It's very accessible. I'm proud of it, and I'll let people know when it's out.
Bruin, of course, the gun case, Bruin v. New York, that
revolutionized the gun Second Amendment.
So Got to ask you about the New York Times piece this past week. You know Adam Liptak. He joined with Jodi Kantor, who's had her name on a whole bunch of really big headline pieces over the past few years, really made a lot of respect for herself. Jodi Kantor, Adam Liptak, this new New York Times investigation that basically reveals the behind-the-scenes story of how the Supreme Court abolished the constitutional right to abortion. Several different takeaways that a lot of people are pointing to. I obviously want to get your take, but number one, Amy Coney Barrett opposed originally taking up the case. Number two, the court created distance from Ruth Bader Ginsburg's death on the issue. Number three, Justice Roberts and Breyer apparently tried to save at least part of Roe. The leak.
Well, Roberts, I'm sorry to interrupt, but Roberts wrote that. That ended up being Roberts' opinion, saving parts of Roe and Casey. That's what he eventually held.
The leak that a lot of people, Politico published a leaked draft of Justice Alito's majority opinion in May 2022, and that rendered those efforts that I just mentioned between Roberts and Breyer hopeless. And then
we don't know that. That's all guesswork there. We do not know that at all.
We don't know that the leak made it hard for anything else to change. Didn't the leak solidify the decision?
I think it is highly likely it was leaked by conservatives, and I think it was highly likely that it was leaked to forestall any possible change, because people have to remember that the right never forgave Justice Roberts for changing his mind at the last minute to uphold Obamacare at the last minute, and Justice Kennedy in the Casey case, which would have been the fifth vote to overturn Roe in 1992, changed his mind close to the last minute. So there is still an argument that the conservatives leaked it so nobody would change their mind. But Breyer and Roberts lobbying to strike down the law, but keep Roe and Casey to the alive for a little while longer, doesn't surprise me at all. That's exactly what happened. By the way, that's exactly what happened with Justice Kennedy. Let's go back to Justice Kennedy for a second. That's how the Supreme Court works. In 1989, Justice Kennedy votes to overturn Roe, but there's only four votes for that. Then Thomas replaces Marshall. There's 5 votes to overturn Roe. And Justice Kennedy famously had reporters in his chambers, right before the opinion was announced, where he grumbled and mumbled and was upset and basically said, I don't know if this is the right thing or the wrong thing. I just don't know. Kennedy was really agonizing over this, which is not a bad thing. I like my Supreme Court justices to be agonizing as opposed to Scalia's get over it attitude. But they were very worried about that happening again. So if I had to bet, if I was a gambling man, I am a gambling man, I would bet that it's the conservatives. But we don't know, and nothing in this article sheds light on that. Nothing in this article sheds light on who leaked this.
Nothing sheds light on who leaked it. But yeah. I get the point is that it solidified the decision. They couldn't change their vote subsequently. Once it was leaked, it boxed them in. That's my
interpretation. But okay. I mean, remember, Justice Kennedy was on record in a Supreme Court opinion, basically effectively overturning Roe. Yeah. And then he changed his mind from what he already wrote. How he already voted.
I guess it's a different time, a different makeup of the court, different political consequences on a different issue.
I don't know. I'm just saying I don't. The thing about the article that's really important, Pete, is if it's true, then the information had to come from either law clerks or justices. There is no other option.
Information gotten by the journalists would have come from law clerks or the justices themselves, and that to you is one of the big takeaways that most of us wouldn't even think of taking away, simply because that would be unprecedented. Normally, law clerks and justices themselves would never talk to 2 New York Times reporters.
Almost unprecedented. Not unprecedented, but almost unprecedented. And in fact, so the Brethren, which was a case written about the Supreme Court way back in the 70s by Woodward and Bernstein, the Brethren caused such a ruckus. What are you doing?
I have a itch on my back, so I have to scratch it. Really bad.
I don't know if I can talk seriously to you while you have a stick going down your back.
It's really bad. It never happens during an interview. If it were somebody else, I wouldn't have done it. But
I feel like this is kind of an intimate, private thing you're doing right now.
And I just climaxed. Okay, go ahead.
The Brethren was this big best-selling book by Woodward and Bernstein that that had a lot of great nuggets in it about the court that they obviously came from the clerks. After that, Justice Rehnquist, when he was Chief Justice, used to threaten the clerks, if you break any confidences, your whole, not just your time here, your career will be ruined. And he would threaten them with that. It's very unusual. And believe me, Pete, I have tried to talk to so many friends of mine, Mike Dorff being one, law clerks. Mike Dorff clerked for Kennedy during the Casey case. In fact, Mike has a blog post on Friday where he mentions that. Mike won't talk about it. Nobody talks about it. They never talk. So if these clerks really did talk to the judges, to the reporters, that's a big deal. I also want to say the inner workings, the machinations that the article talks about, Pete, about holding on to the votes and trying to change the votes, and Roberts trying his best to get one more vote. That happens all the time. That used to happen all the time on the Supreme Court. What's changed is the 6-3 conservative. There's no longer our cases are now 6-3, not 5-4. Most of the highly charged cases, and that gives the conservatives such breathing room that it's much less important. I think Adam Liptak's a friend, and he's a great reporter. I do think people made too much of this, and I didn't see a whole lot of stuff in there that would have surprised me or that I didn't already know. A lot of it is just confirming what we already thought. The thing about Barrett is interesting. Why did she not want the case to be taken up her first year or her second year?
Yeah.
There's an obvious answer to that.
She didn't want it to be on her. Everybody would have blamed, history would have blamed a woman for a lack of reproductive rights.
They still should blame a woman because without her vote, Justice Roberts' concurring opinion becomes the majority opinion, and Roe versus Wade is still alive. It's not so much that, Pete, is a lot of liberals like me in the media have said over and over again that they really wanted Amy Coney Barrett on the bench when they reversed Roe because they wanted a woman, even better, this is just true, I'm sorry, an attractive woman on the court to destroy abortion rights forever. Right. So I can understand why she did not want that to happen right away, not to mention how disrespectful it is to Ruth Bader Ginsburg, who, fought for gender rights for 60 years or something, 65 years. So, I don't know. I do know that Amy Coney Barrett is deeply conservative, deeply libertarian, and will continue to be that unless hell freezes over.
All right. Anything else about that article that you want to react to? I'll
just tell the audience one thing Adam Liptak once told me that I thought was really interesting about covering the court. So a few years ago, I had Adam Liptak, Dahlia Lithwick, and Robert Barnes, who is the Supreme Court reporter for the Washington Post. Robert just announced his retirement starting next year. Those are three of the most important Supreme Court reporters in the country. Dahlia's on your show all the time. Adam's New York Times. Robert's the Washington Post. And I asked them at a lunch thing I was moderating, what's different about covering the court? And Adam had a great answer. They all had a great answer. They all said the same thing. They all said when people cover mayors or presidents or governors or members of Congress, they give press conferences. You raise your hand. They take questions. They answer them. Their politics comes out in the give and take of the media. They never, ever get to ask Supreme Court justice questions ever, which makes it very hard for reporters, obviously. So they have to really work hard to get their sources. In that sense, this article, long and detailed, is pretty impressive. Just assuming that everything is true, which a lot of people are not, by the way, but assuming everything is true. But it didn't break anything that could be called a front page story.
Huh. Interesting and fascinating. And glad I asked you about it. The other thing I definitely wanted to get your take on, I saw you tweeting about this, the heartbreaking story out of Texas with this young woman, Kate Cox, who was unable to get an abortion, who was threatened that she would be subject to criminal penalties, as would be the hospital and doctors who might perform that abortion on her. With those questions in the air, nobody's going to perform an abortion in those states, and women are going to try to go to other states to get their abortions. Obviously, the details of this story are heartbreaking because of the situation with the fetus and her own health. But you said this would happen. We're seeing this happen. We're probably not seeing many times, other times when it doesn't happen. We all heard about this young 10-year-old in Indiana who I think had to go to Ohio to get an abortion. Yep. All of this plays out in our politics, in our elections, obviously. But what are your thoughts?
I'm going to skip right to the bottom line, Pete. I'm going to skip right to the bottom line. Bottom line kind of guy. One can be pro-choice, pro-life, One can be against abortion with every fiber of their being. And one can think that the killing of a fetus is murder, punishable by whatever murder penalties we have. This fetus was never going to live. So it is an organism in this woman's body that is dangerous. It's much more dangerous to keep it in than take it out. And by the way, just for the audience, someone very close to me was in exactly this position a few years ago. A woman who I'm very close to really wanted kids and couldn't get pregnant, and finally did. And there was so much joy and so much celebration. And then at 15 and a half weeks or 16 weeks after the amnio, found out the fetus was going to die. And it killed her. It just killed her. And she's not even, I don't even think she's pro-choice, but she got an abortion because the doctor told her this could if you keep it to term, it's never going to live. And it may decrease your chances of getting pregnant again, which is true for this woman as well in Texas, who also wants more kids. She already has two. She wants more kids. And the bottom line on this is the government, neither the government nor any citizen of America should have any interest in a dead fetus in a woman's body. The only person who's interested in that is there's nobody else. We can debate abortion until the end of time, but this was a medical hazard too. Now, I want to make a legal point, Pete. The Supreme Court has held on several occasions that adults have a constitutional right to refuse unwanted medical treatment. As long as I'm competent, obviously if I have Alzheimer's or dementia, no. But if I'm competent and I'm 79 and I have a terrible cancer disease or something, and I don't want any more medicine, the government cannot make me take it. Now that right is not in the Constitution. The court made it up. Now you and I both think it's an important right, but it's not in the Constitution. So just for the record, but it's there. When the fetus is terminal, when the fetus is never going to be able to live, then that adult needs to have complete and full autonomy over her body, just like if she had some kind of terrible invader disease in her body, she'd get to decide whether she wanted it cured this way or that way, not cured at all. That's her decision, as long as the doctor says it's willing and the medical rules to do it. So here we have, and I asked some very conservative con law professors, what legitimate interest does the state have in a dead fetus, and what's going to be a dead fetus? And their answer, by the way, was none. Right. If the fetus is dead, then the woman should do whatever she gets to do whatever she wants. That's how it should be. And
it seems that in layman's terms, when we hear about abortion, we hear all the time with exceptions so that people can wrap their head around this. But it feels like what we're seeing actually play out now is there are no exceptions, including if the fetus is dead, health of the mother, rape, incest. Those are what we usually hear. But this is one we don't hear quite as much, but it's a pretty clear-cut case. Well, not an exception, though.
The other thing is the Texas Supreme Court just lied. They just lied. It didn't matter because she left the state, but in upholding, in reversing and vacating the lower court opinion that gave her the right to have an abortion in Texas, because there is an exception. If the woman's going to die, that's an exception in Texas, or major substantial bodily impairment. And this woman absolutely has a risk of major bodily impairment. There's no question.
And all of the physicians in this case, in most of these cases, are on the same page with about the best way forward.
So what the Texas Supreme Court said was the doctors in this case and the lower court judge didn't use the right language in describing what they were doing to come in under the statute. And that just wasn't true. The doctor said there's going to be major impairment there could be major impairment to major organs. The whole thing is tragic. I just want people to understand the person who was close to me who this happened to, Pete, really struggled with what to do.
Sure.
And it wasn't until the doctor said two things. Fetus has no chance of living, and this may hurt your chances of getting pregnant again. And she became certain because it turned out she had two kids. Thank God. Blessing. It happened. If she had kept that fetus in her for 40 weeks, I don't know if it would have happened.
How does she feel about those 2 kids? Do you know?
Pretty positive.
That's good. Happy to hear that. Yeah, okay.
So anyway, I don't, again, I've always said on your show, I am pro-choice radically, but people can reasonably disagree on what the right answer to abortion is. I do not think it's an issue for courts. I think it's an issue for voters and electors and that kind of thing. But not at this, not here, not where there is no possibility of fetal life. The woman then should have absolute, with medical, whatever the doctors are willing to do, she should be allowed to do.
Is there anything else to say about where we go on this right or other women's reproductive rights? You're hearing now talk about new cases about the mifepristone pill. We could hear cases could be brought, I suppose, about birth control. Mifepristone is abortion, medical abortion, which is how most women now get abortions, apparently. But there's all kinds of reproductive rights and access to contraception and other services. I mean, where we go from here with the current makeup? Anything else to say about that before I ask you about Rudy Giuliani?
Yeah, I don't know.
Who also is an abortion.
I'm very
His career should have been aborted, but I'm sorry, go ahead.
Yeah, that was good. I agree. I'm not optimistic. I don't think we'll get back to states being allowed to outlaw birth control, but we may get back to states making it harder to get it. That could happen. But on just about all issues involving women, I am not optimistic, which, by the way, Erwin Chemerinsky and I, way back, like in 2000, remember the defund Planned Parenthood crazy stage where all they could talk about was defunding Planned Parenthood? Yeah. He and I wrote a piece together. He's the dean of Berkeley Law School and probably the most famous law professor right now in the country, one of them. And he and I wrote a piece together because he has daughters also. I have 3. I think he has 2 or 3. About how worried we were about our daughter's future. And this was during the Obama administration. But we were worried that if the Congress goes Republican, all this. Anyway, we wrote that like 10 years ago. And we're still equally worried today. And that's really sad.
Wow, that was punctuated by a computer sound effect that I can't.
I don't think your audience can hear that.
No, I think they can. I'm sure they can, as a matter of fact. So the other...
Just say I suck. Just say I suck, and we'll be fine.
The other issue I want... To be fair, folks, he uses an Atari to talk to me. Rudy Giuliani has had a real fall from
Rudy!
You know Rudy, and it's the one thing when I ask you, what do you want to mention? What do you want to talk about? It's the one thing you definitely, I know, wanted to talk about. And I want to talk about it too. I mean, I've hated him for a long, long time as a New Yorker, knowing that black and brown folks despised him before 9/11. It was particularly outrageous that most of the city did not like our mayor, including me, for a lot of different things. And then 9/11 made him a hero. And that was always stupid because he literally put the 9/11 command center in the one building that had been attacked before by terrorists, the World Trade Center, and it collapsed on itself. And then he was made out to be a hero, and he didn't really do anything other than any other probably mayor wouldn't have done in a similar situation. I always get irked by that. Andrew Cuomo was go good during COVID. No, he wasn't. He sat next to a couple scientists and answered questions as best he could, and that made him a star. Any good governor would do that. I'm not giving him credit. But his fall from grace is just epic. And, you know, I was texting you the other day.
Let's be clear. He was never at grace. He may have been grace in the public's eyes, but he was never at grace.
Fair enough. So what do you have to say about him?
Well, I have a personal story about him, but it also is a story about constitutional law. So I think it's a good way to end this. So we have to go back in time, go back in your time machine, and we're back to 1988. And by the way, the irony of this is going to be very apparent very quickly. So in 1988, in the Middle East, the PLO was the major player, for that side of the equation. The Palestinian
main representative was the Palestinian Liberation Organization led by Arafat.
Yes. And they had what's called an observer mission to the United Nations. They're not a country, so they couldn't, but they had this semi-legal status, or legal status, where they can't vote on anything, but they could observe. This is what it was. But for that, they needed an office, they needed space, they needed money, they needed pencils, whatever. That's not so. Congress, and there's no question the PLO was, I hope this isn't controversial, the PLO was engaged in terrorism. I mean, it just was. I mean, I'm not taking a side on anything. I'm just saying they were engaged in terrorism. So Congress was really worried about it. So Congress amended a terrorism law to say 2 major things. First, close that mission to the United Nations, kick them out of our country. They don't get to be at the United Nations. That's the first thing. Second, and this part should immediately strike you as a little bit crazy, the law said anybody who receives anything of value from the PLO to further the purposes of the PLO commits a crime. Wait, why am I hearing a terrible echo, Pete? Okay, it just ended. Okay, so that second part of that law, Pete, is obviously a violation of the First Amendment, right? I mean, I can't advocate, I can't plan a terrorist attack, but if I want to say the PLO is a good organization that deserves to be sitting in Jerusalem and they pay me to do that, and that's a crime, we have a real problem. Because that's, anyway, so those are the two big issues. Now, one more background point. The way the United States Department of Justice works is the following. Main justice is in Washington, D.C. That's where I was a trial lawyer. In every major city in America, there's a U.S. Attorney's office. Those U.S. attorneys handle 98% of federal cases, not the Washington Department of Justice. In Atlanta, we have a huge office with 30 attorneys or more. And that's true all over the country. What DOJ does in Washington is it farms out all the easy cases, but the really hard, controversial national cases are done out of Washington. And that's been going on forever. So when I worked on the when the Iran-Contra issues came up, I worked on that out of Washington. Lockerbie, I worked on that out of Washington. Major First Amendment case in San Francisco involving public and private schools. I worked on that out of Washington. But that's very rare. Most of the cases are handled by the U.S. attorneys. All right. So now, this law says the president shall close the mission to the United Nations. Shall. And when the law was first being discussed and then passed, there were people at the Department of Justice who were very upset about the word shall, because they said Congress can't make the president file suit. That's a violation of separation of powers. And there was a memo that said that. So that was in the background of this, that really, can Congress require the president to file a lawsuit to shut down the mission? That was very controversial at the Supreme Court, at the Department of Justice. Eventually, they decide they are going to file that lawsuit. Secretary of State George Shultz did not want to. Ed Meese, Attorney General, wanted to. Reagan sided with Meese. That's what happened. Shultz wanted no part of this. He thought this was a terrible idea for international purposes, but Reagan went with his buddy Meese. Not surprising. So now the question becomes, and it's in the Southern District of New York. The lawsuit is in the Southern District of New York. Rudy Giuliani is the United States Attorney for the Southern District of New York. And I was told on my first day, I was told several things about doing well at the Department of Justice. One of them was try to avoid any cases involving NASA, try to avoid any cases involving HUD, which I did not get to avoid, unfortunately. I had a terrible housing case. But also, if you're dealing with the Southern District of New York, that's different because there's a history of it being different, and also Rudy is different. And it's very so. But eventually, so I'm doing the research for the brief. This is going to be a front page case. So I'm helping on the case. Then the question became, who's going to argue the case? And there became a turf battle between Ed Meese and Rudy Giuliani, because Ed Meese wanted that argued out of Washington by a Washington lawyer, a political appointee. Rudy wanted to argue it himself. When that happens, people, 99.999999% of the time, main justice wins. Main justice rules. Not there. And Rudy Giuliani argued that case. And I was told he was going to go to war about it if he didn't. And I make that point because this man has wanted to be in the public eye and wanted publicity his entire career. And you're right. 100% right. 9/11 washed away a lot of the terrible things he did. Now, not everything he did was terrible, and we shouldn't pretend it was. I think he did some positive things for New York. But on balance, he did positive things for rich New Yorkers and tourists. He did nothing. Yeah, he did nothing for the residents of New York City. But here's the con law part that's fascinating. We all thought, of course we can close the mission. I mean, the president wants to close the mission. He's going to close the mission. And there's no way we're going to win on the First Amendment issue, because think about a law that said it is illegal to receive money to say anything supporting Hamas. Well, No, you can't. That's what we call a viewpoint-based restriction on speech. I can say anything I want about Hamas, even if Hamas pays me, as long as it's negative. But if it's positive, I can't say it. We don't want the government doing that, right? That's enough.
Right.
Okay, we've talked about life tenure since the first time I was on your show. We have talked about the idiocy of life tenure. Of course, we get like a judge 114 years old who passed away shortly after this case, some couple years after this case, and he ruled exactly the wrong way both times. He said we could not close the mission based on a lot of technical and false arguments about treaties, but the other law did not violate the First Amendment, and it should have gone exactly the other way. And it's once again an example of constitutional law and wrong. But about Rudy, the fact that he was able to win the turf battles that he fought in that case shows you the fear of him. By the Department of Justice people.
Yeah.
I mean, that's like J. Edgar Hoover stuff. Like that's crazy.
His entire career was one of intimidation and bullying, and it got him very, very far. He destroyed a lot of people along the way, and in the end, he destroyed himself, without a doubt.
We should realize that he's not going to have to pay 170 whatever it was $1 million. That's going to be knocked down a lot on appeal. Doesn't matter. There's going to be a lot upheld on appeal, I think. And he can't afford $5 million, I don't think, much less 170 million, whatever it is they did.
Well, he's going to have to sell all of his assets. He's going to have to file for bankruptcy. He's never going to be.
Well, you can't discharge. You can file for bankruptcy, but this verdict, when it's entered in final, cannot be discharged in bankruptcy. Any money assuming this verdict is upheld on appeal to the tune of $10 million or $20 million out of the $170 million that it was, every penny he makes for the rest of his life will go to these women.
What is hard is that he has a whole bunch of assets that he has somehow protected that they can't find, and they've been trying to. Apparently.
Is that true?
That's what I heard some reporting about that, but that's not unsurprising with someone who has a lot of money, and even if they aren't under criminal investigation, that they put that in places that governments can't find.
Yeah, I was surprised to see somebody respectable on Twitter showing a clip of Rudy, a very short one, where he seemed extremely in the moment and clever and sharp, saying, what we've seen over the last couple of years is performance art, that he likes to appear drunk and babbling and on beds with whatever it was. But in reality, he's actually not that sick. In reality, he's actually.
I don't know about that, but I
don't know either.
Your comment on the decision itself, I mean, like defamation and what he did and how the court handled it, like there was never any question that he did it. And by the way, came back out, not unlike his buddy Trump, who also has destroyed himself in many ways, with E. Jean Carroll losing a defamation case and then coming out to the microphones and continuing to defame, thus creating potential for another defamation case.
Yeah, it's unbelievable. Well, once you're $170 million in the hole or whatever it was, how much more can it be? I have a lot of problems with defamation law in this country. I think you and I have talked about this. I actually have some sympathy for Justice Thomas's policy arguments.
Wow.
Huh. Well, in this sense, I don't think Tom Cruise should have to prove actual malice if the New York Times says he's having an affair that is not happening. I just don't think he should have to prove that. I think political officials should have to prove that. I think a government official should not, we should be free to criticize government officials with a huge breathing space, for political speech. But if I say Tom Cruise is having an affair, and his wife is cheating on his wife, and it's not true, they have to show not just that it's false, but that I knew it was false. And I don't think that's right. But in this case, what he said about these election workers was terrible because A, it endangered them, it endangered their lives, B, was hopelessly false, and C, was a way to, keep the big lie going. And those are very serious things. And I'm sure that's part of the jury verdict.
Well, right. Yeah, that's an important distinction. Although your example for Tom Cruise could have been a different rumor that would have been equally as defaming.
He's gay? You mean Tom Cruise is gay?
I mean, it's actually a perfect example because people do accuse him and other people of their sexual orientation being or not being something. And that's the same point I think that you're making.
I'm not sure, but being called gay is probably not defamatory.
Than cheating?
That's defamatory. Cheating on your wife is defamatory. Just being gay, I don't know if that's defamatory. I don't think it is. Shouldn't be.
Okay. Well, I mean, the bottom line is a thing isn't true about you.
Who knows? Pete, one more thing about Rudy. I hope that it's one thing. He's just betrayed so many different important values. The criminal justice system in this country is hopelessly racist. It was even worse back in his day, and he made it worse.
Yeah.
He absolutely made it worse.
Oh, yeah. Stop and frisk. Yeah.
Yeah. Getting in bed with Trump is inexcusable for this reason, Pete. I don't think anybody is saying this is not a smart person, and I'm not saying that. I saw him at work.
Sure.
I think he's actually a very smart, intelligent man. No, I do, in that lawyer kind of way. For him to get in bed with Trump is just, it's going to destroy his entire reputation and life, and it should.
Let me just ask you about Trump. This last week, Jack Smith appealed directly to the Supreme Court on the question of, is Trump immune from these federal charges because he was president? Tell me a little bit about what happened there and what you think it means.
So the court held that he doesn't get immunity, and he shouldn't get immunity because he was not performing official functions. He was running a campaign out of the White House. I think the Court of Appeals will definitely say that. What the Supreme Court says is anybody's guess. There's also an argument that an oral argument in the 11th Circuit in a different case questioning whether Mark Meadows, his chief of staff, can remove the case to federal court because he's no longer a federal officer. Federal officers get to remove cases. That's going to come into play too. I think the timeline, all the court did, by the way, this is a great example of the media getting it completely wrong. Makes me so frustrated. The media reported the Supreme Court agreed to expedite that immunity question. That's not what they decided. They decided to decide whether to expedite. They expedited the decision whether to expedite. They have not yet expedited it. Those are two very different things. Am I being clear on this?
I bet you for other people.
Say again?
I bet you for other people listening, they followed that.
So a party makes a motion, want an emergency appeal, Supreme Court grant it right away as opposed to the regular course. What the court said is, we'll hear argument on that question very quickly. But they didn't resolve the question. The media reported they're going to resolve the immunity issue quickly. They never said that.
That's better said. Yeah, got it.
If I was the Supreme Court, this is a tough one because the election's around the corner. Per Rick Hasen, the election law expert at UCLA, who's been on your show a few times. Rick has been warning everybody. We need certainty. We can't go into 2024 without Trump's status being certain. So the court might expedite it and resolve it for that reason. But I don't know.
What status do we need? What specific status do we need resolved before the election?
Whether he has immunity from prosecution for the things he did, from criminal prosecution, for the things he did while he was in office. And that applies to both Jack Smith's lawsuit and the lawsuit in Georgia as well. I thought,
and you're saying that's a tough question, whether or not he has immunity. I thought
No, not at all. I am saying there's two different issues. I'm sorry, I'm not being clear. One issue is, can these federal defendants like Mark Meadows remove his case from state to federal court? That's actually a complicated issue. That the 11th Circuit had an argument on Friday. They're not going to grant it. Your argument, our friend Judge Pryor, Bill Pryor, he who hires clerks who say, I hate all black people. Bill Pryor was very skeptical of Mark Meadows' claims. He's going to lose. And Trump didn't try to remove the Georgia case. In the federal case, he's arguing, as president, I can't be charged with crimes for things I did in office. Pete, that argument can't win. If that argument wins, then we are really, really...
Yeah, well, when you're president, you can do it, I thought.
Yeah, but no, before we go, I just want to be very clear about this. What they are arguing is for anything the president does, which is even anywhere near his authority. I don't think they're saying he can go on Fifth Avenue and murder a person in cold blood. But for anything that implicates any official duty, he's forever immune from criminal prosecution, would literally put the president above the law in a way we cannot tolerate. And there should be civil disobedience if the Supreme Court rules that.
Oh, yeah.
That's crazy. I don't think they will.
You also, though, said about this and other cases involving January 6th that Thomas Clarence Thomas should recuse in any case because Ginny Thomas, quote, urged Meadows to help in the results. Quote, Biden and the left is attempting the greatest heist of our history. You tweeted that Thomas should recuse in any case. It's not just reasonable to question his impartiality. It's necessary.
Before I answer that question in the 5 minutes we have left, I want to establish my credentials first. In 2012, the left argued Thomas had to recuse from the Affordable Care Act case, the first case, the big Obamacare case that could have struck everything down. And I said he shouldn't recuse. I didn't know all the facts at the time. But what I said in the LA Times in an op-ed was we need to be very careful about recusing judges because of their spouses' activities, because that will hurt women in the long run. And also, it's just a bad idea. Now, if the family has a financial stake, that's different. What I didn't know was that Ginny Thomas had a financial stake in a lot of this stuff, in addition to a political stake. He absolutely should recuse about January 6th because we know that she has called that a fake, it wasn't she's defended it. She was there, Pete. She wasn't at the Capitol, but she was in the crowd during Trump's speech. Ginny Thomas was in the crowd at when Trump spoke. And we know that she sent emails to Mark Meadows about it. We know that she talked to Arizona legislators about the steal. No, if your spouse is that involved directly, then you have to recuse. My argument in 2012 was we had no evidence that she had a financial stake in the Affordable Care Act or anything else even close to that. All we knew was she lobbied against it. Just lobbying against the Affordable Care Act, I don't think is necessarily recusable for Justice Thomas. But here, she wanted Trump in power for both political reasons and personal reasons, because that brings us to the last topic of the day, which is the Heritage Foundation, which is turning out to be the worst, much worse than the Fellow Society and much worse than Cato. Heritage has gone full Trump. FedSoc has not. In fact, FedSoc is leaving Trump behind. But Heritage is embedded with Trumpians. It's really, really sad. Ginny Thomas worked for Heritage. That's what I didn't know, and got paid by Heritage to do many things over a long period of time. Justice Thomas has spoken to Heritage, raising money for Heritage numerous times. He never disclosed his wife was a paid employee of the place where he was speaking. Think about that for a second. Clarence Thomas goes to an ideological group, gives them a nonpartisan talk, never disclosing his wife is being paid by that organization.
Is this is that a new reporting, or is this an old gripe?
There's some new and some old. What is? We did not know the extent of Ginny Thomas's connections to Heritage until relatively recent. We knew she had been paid for a couple of things along the way. No, she was like a real employee for a long time. And worse than that, during Bush versus Gore, she was trying to get jobs for Republicans, assuming Bush was going to win, and got paid for finding jobs in the administration. Thomas should have actually recused in Bush versus Gore, it turns out, because his wife is finding jobs for Republicans if it's a Republican administration. Her livelihood is dependent on there being a Republican president.
Right.
And he should have recused back then. So he should recuse in the January. But I also said in that LA Times op-ed, I gave my arguments, and then I said, but even if you disagree with me, please don't expect Justice Thomas to do the right thing. He never has. Right. Why would we? He's not going to do the ethical thing. I gave many examples of that. Like he's not. Pete, very, very last thing. He submits his wife's income as he's required to do for years. He does it year after year after year. Then he stops doing it for like 10 years. They catch him. He says, I'm sorry. He actually doesn't say he's sorry. He says it was a mistake. He refiles. Then he does it again. He's a Supreme Court justice. The form says, tell us who your wife is working for and how much she's making. How hard is this?
Yeah, there's no doubt about it that he purposely hid that information.
So with that background, yes, he should recuse.
I know you got to go. I just got to ask you about the impeachment inquiry. You're a con law scholar. You saw what Republicans in the House did last week. Did you seen any evidence of high crimes?
The only thing I'm going to say about that is it strengthens my argument, and I think one of the few progressives who are making it loudly, that we should not use Section 3 to get rid of Donald Trump. Because if we give that weapon to Republicans, they'll use it much worse than Democrats. They just will. If and I'm very worried about this, Pete. I am really
okay. Well,
about
that was a real left turn to crowbar that. How was that connected?
No, it's not. The point I'm making is any dirty trick or even fair and honest legal trick that the Democrats use, Republicans will take it and make it much worse.
Yeah, but I'm asking you about impeachment.
Well, Biden did nothing to be impeached. I've read a little bit about what Hunter Biden did, but as far as I can tell, there's no evidence that Joe Biden did anything. Do you have any evidence Joe Biden did anything?
What I'm wondering is, and I haven't gotten the answer, maybe this is nebulous, but I guess you can impeach the president or anybody else that you can impeach for things they did before they were president, right? They're not even insinuating that.
No, I would not. No. I would not think so at all.
Well, they're not. I'm unclear with.
Hold on. I guess it has to be for a high crime or a misdemeanor, and misdemeanor doesn't mean what we think it means. It's serious crime. It has to be a serious crime, probably a felony.
Because Donald Trump committed all kinds of crimes before he was elected, including rape. So.
I'll be honest, Pete. I haven't thought about that issue. Can you be impeached for things you did before you were president? If we found out that Joe Biden murdered somebody in cold blood, could he be impeached for that? He'd be put in jail for that. So I think then he couldn't do his job. So I think we use 25th Amendment.
Yeah, my understanding is that they're investigating things that happened.
So that's my point.
Transactions, financial transactions, they're saying happened before he was president.
But this is my point. So both of Trump's impeachments were real impeachments that actually he should have been impeached for what he did. His phone call to the Ukrainian president is absurd. It's absurd phone call.
He said, if you want your weapon, investigate my future likely opponent, Joe Biden. Yeah. And that was,
and weapons, you have to investigate. No, not investigate. Say you're investigating.
But even more importantly, the difference, of course, and it really does matter with that and what they're saying about Biden is we heard the call. We heard it.
Yes, I know. No, my point,
you can say anything you want.
That's my point. You accused me of crowbarring, but I wasn't crowbarring.
You were crowbarring.
I wasn't crowbarring. I never crowbar. Almost never. I crow.
It was a crowbar. I saw a crow and a bar.
Yes, Seinfeld. Yes, Seinfeld. Now I want to do Larry David. I'll try to put that in a second.
He was crowbarring.
Pete, you're pretty wrong here. Pretty wrong.
All right, not bad. Not a bad Larry David.
Right? For law professor, not terrible.
Not bad.
I'm pretty sure I'm right about this. Because the Democrats acted legally and properly in trying to impeach Trump, the Republicans are going to act improperly and illegally trying to impeach Biden. Now, imagine a case where under Section 3, we won't go through it right now, we got to go, there are many unanswered legal questions, many unanswered factual questions about whether he should be disqualified. If the Democrats use Section 3 to disqualify him, the Republicans will start disqualifying people for disagreeing.
Right, I understand, but that's...
No, they will, Pete.
I know that. I know, but you're.
I'm not persuading you, and I'm mad.
No, what I'm hearing is that we shouldn't enforce the law because that means somebody else will enforce the law.
No, I'm not saying that. If he was 33 years old, he can't be president. Got to be 35. That's the law.
Yeah.
The law here is applying a vague term, insurrection, to a contested set of facts, Pete, and there's no clear answer. I am not convinced Donald Trump engaged in insurrection. Well, I can make the argument he did. I can make the argument he didn't. Reasonable people can disagree. But the Republicans will use that tool where people can't disagree. That's the problem. We shouldn't give it to them. We should not give it to them.
They will use it anyway.
No, they won't. If this goes away, I don't believe they will. If it becomes a big deal, yes, they might. I got to go. I love you, buddy. Take care.
Thank you, bud.
All right. Take care. Bye.
All right, there he goes, Eric Segall, everybody. How about it? You bumblebees here at the end. That's your nickname if you listen all the way to the end. You know who you are. I so appreciate you. Heard from the Sandman yesterday and always want to hear from all of you bumblebees listening to the end of the show, learning, laughing, and finding the way through all of it with me here each and every day. Thank you. Thank you, Eric Segall. Always awesome. I love talking to him. I learn so much, and the things I forget, I love to be reminded by. So always a great conversation with Eric. Go sign up for a paid subscription if you haven't, and watch my stand-up special right now. Drybarcomedy.com/PD. I mean, you don't have to do it right now. There's a link in the show notes to get there, and Write a rating and review on Spotify or iTunes. That matters. That's currency. And if you haven't ever done that, maybe today you could put that on the old list for me. All right. Thank you. Do you have a list? I don't think I need a list. John Carroll taking us out.
Well, there's a whole lot more of us who know us right. They'll keep right on ignoring us if we keep sitting tight. You got to open up the window to let in some light. You got to stand up. That's right. You got to rise up. You got to stand up. You got to stare the devil straight in the eye. We got to let him know it's his turn to go. See it clear and all you hear is a lie. So get up off of your butt, get down off of your fence. Even if it ain't a very friendly audience, so they'll begin to listen when you start making sense. And you stand up, stand up. No need to point your rifle to defend your town. Just stand up, stand up. You know they can't deny you what you're laying down. Boy, you better stand up, stand up. Show your face of every color, yellow, black, red, and brown. She's the place where every lost child will finally be found. There's only one thing to do before we stand our ground, and that's stand up, stand up. Well, the founding fathers saw a land for all. They had to stand up, they had to stand up. They had a keen imagination for a crystal ball, drawing all the plans of a stand up. But all they had to go on was the time they were in, with other causes for laws, and since they weren't even sin, they knew that change was gonna come before the change could begin. They had to stand up. All right, they had to stand up. We got to stand up. We got to look the devil square in the eye. We gotta let him know it's his time to go, and make it clear when all we hear is a lie. Why you lying awake wondering where the money all went? It'll be the cost of freedom that'll go unspent. You can see him flee the scene of that experiment if you stand up. Alright, we got to speak up, we got to reach up, and raise your voice in every way you know how. Don't be toes up, you got to show up. Ain't no better time to do it but now. No need to pledge allegiance to no wanton tribe. Rise up and show obedience to the voice inside. And listen well and it'll tell you not to run and hide. It says stand up.